The problems with New York's state legislature are so entrenched, so embedded in the structure and tradition in Albany that most New Yorkers believe nothing can ever change. How could it, when thanks to gerrymandering, legislators might as well be elected for life, and their permanence is matched only by their powerlessness? All the important decisions are made by three political bosses, the governor and the leader of each legislative house. The budget is written in secret code. The lobbyists have free rein even with government officials. The list goes on with many of the worst abuses cataloged recently by Raymond Perez Penn and James McKinley Jr. of the New York Times. But a few key reforms could make all the difference and give New York's 10 million residents the government they deserve. If the Berlin Wall can come down, there is hope for Albany. The first crack in New York's petrified legislature requires a fundamental change in the way legislators map their own election districts. If there is one single thing that could relieve the gridlock in Albany, this is it. The legislature does this remapping every 10 years, and last year legislators basically mapped themselves back into office. To assure that it doesn't happen again, Governor George Pataki and the legislature should have the courage to act now, when the next changes are still a very distant 10 years away. They should create a nonpartisan redistricting commission with civil service experts doing the detailed work. The legislature should vote the final plan up or down, no amendments, no funny business. New York State runs a $90 billion business that's as hard to follow as the accounting dodges in the corporate world. Money hides in pockets, flows in mysterious ways, and makes it impossible for anyone other than a few savvy experts to know what is going on. The state needs an independent budget office, much like Congress, to get revenues and to demand that New York's books be understandable. Now, lobbyists do not have it and do not have to report what they spend trying to influence state officials. New Yorkers deserve to know what companies are doing to win the favor of the people who issue contracts. The legislature has no excuses not to remedy this one swiftly, since the state's lobbying commission has been pushing for this change for the last 6 years. Attorney General Eliot Spitzer's next stop after Wall Street should be the halls of his own state capitol. Mr. Spitzer bemoans the uncontrolled way in which New York politicians raise money for election campaigns and the resulting cave-ins to donors on issues like smoking, gambling, car rentals, and more. He should be brave enough to embarrass his colleagues the way he has embarrassed the stock market's worst operators. But the Attorney General can't fix the law. Only Governor Pataki and the legislature can do that. Mr. Pataki, Assembly Speaker Sheldon Silver, and Joseph Bruno, the Senate leader, have separate reform bills showing that 3 separate bills in Albany means no bill at all. In Congress, such differences can be hammered out in a conference committee. Albany's leaders need to appoint a committee for this critical issue and let conferees actually do the real work of creating a compromise. Crafting it and redistricting aside, there are other ways to bring life to the legislature. Senators are still talking about a startling event last month when Mr. Bruno allowed a bill for gay rights to go to the floor, even though nobody was sure it would pass. With an uncertain outcome, the debate suddenly mattered, and a few orators actually rose to the occasion. In Albany, this was greeted as the legislative version of Halley's Comet. Mr. Bruno and Mr. Silver have absolute control over which bills go to a vote and which to the shredder. Important bills are rushed through in a single day and voted on by compliant lawmakers who have never even read them. the legislature needs to find a workable system, like the motion to discharge in Congress, that shows a popular bill to come to the floor when enough legislators want it. It should give the committee real responsibility and the power to actually write legislation, and it should junk its system of proxy voting. Legislators can report to duty in the morning and wander off while the record shows that they have voted all day. If legislators pretend to work, the taxpayers should pretend to send them paychecks. To succeed in Albany, a politician must please the leaders, not the others in the legislature. Mr. Bruno and Mr. Sheldon are to be, those judgments were anathema to anti-abortion groups, which have been trying to scare women away from abortion by raising the specter of breast cancer. A group of 28 anti-abortion members of Congress complained to Tommy Thompson, Secretary of Health and Human Services, that the Institute's formulation was scientifically inaccurate and misleading. So in June, the Institute removed the fact sheet from its website and later replaced it with a statement that some studies have found an increased risk of cancer while others have not. That statement, while technically accurate, is such an egregious distortion of the evidence that one can only hope it is an interim statement, as some staff members suggest, not a final surrender. The Institute plans to address the issue at a conference on pregnancy and breast cancer in February.
So sad.
134. Ready? Judge Lockman, Mr. Pollack, ladies and gentlemen of the jury, we are now at that phase of the case where each attorney under law is permitted to deliver what is known as a summation, a closing argument as opposed to an opening statement, to review the evidence in the case and talk about what has just transpired in the courtroom over the last two and a half weeks. That is my chance on behalf of my client to talk to you with the voice of reason approach to what we've heard from the courtroom. Before we get into that, though, at least two of you know that some of the things we mention in jury selection, specifically dropping the phrase alternate from alternate juror, comes into play because you will be deciding the case. In jury selection, I discussed with each of you, and I specifically said I would not treat any of you any differently from any other. Everybody has the right to bring a lawsuit, make any claims you want, and I used the phrase prove versus disprove. And we discussed that with each of you when I was addressing you during jury selection. Now, we're going to start with Mr. Pollack's opening statement, and of course you do not have to accept my word in what I'm about to tell you because it's down in the transcript. But the case began with Mr. Pollock's opening statement in which he said certain things to you. And I do apologize. During portions of my summation, I will be reading to you from transcripts. So I have the language exactly, especially in connection with Mr. Horowitz, when I'm reading questions and answers. But to start with, Mr. Pollock's opening statement, he was telling you about the dispute in the case as to when the complaints first arose when Mr. Gerson, following the operation, and he said there is a dispute in this case about how long it was after the surgery that these things appeared. And then he went on to say, the dispute about the timing we don't think is important. Now that's what he told you in his opening statement. The dispute about the timing, the plaintiff does not think is important. Obviously, you know that that's incorrect because Dr. Horowitz testified and he had a report here in court in which he said the continued compression over this length of time is sufficient to produce the neurological problems Mr. Gerson had immediately post-operatively. So when Dr. Horowitz, whenever it was that he first found out about this set of circumstances, and you know that was after the lawsuit had started, because it was sometime in 1985, he said in his report that Mr. Gerson had these things immediately post-operatively. So obviously Dr. Horowitz felt that the timing of these things was important, otherwise he would not have said that he had them immediately post-operatively. The problem with Dr. Horowitz, and we'll get into Dr. Horowitz's opinion at length, is that that report is riddled with mistakes, mistakes of facts, and mistakes of conclusions. For example, he states in here that the patient was given Demerol and Phenergan. Then he later admitted, despite the fact that he put in a lot of these of time reviewing the chart, the use of Phenergan was a mistake on his part. He kept to his position that the plaintiff was heavily sedated during this period of time. And we're talking about from October 2nd to October 7th, and I believe the question was put to him by Mr. Brenner to try and ascertain exactly what Dr. Horowitz's position on this case is. And the question was, is it your position then that you feel Mr. Gerson was so heavily sedated and medicated during the 5-day period that if he had the complaints, he could not express them, and that's why the nurses did not make any entries in the chart during those 5 days? And the answer is yes, that's true. The point is, obviously, Dr. Horowitz felt the timing about these things is essential. He said it in his report that he had it immediately, and he attempted to say the reason why it's not in the chart is either the nurses failed to put the complaints down or the patient was unable to understand that he, in fact, had these complaints to make to the nurses. But he never once told you the timing. I don't think it is important. So here we have it. Since the very first thing Mr. Pollock told you in his opening statement, the thing of this dispute, we don't say that is important. The witness that puts it on the witness stand goes right for that and attempts to explain it away as best he can. The mistakes in this report that was submitted, Mr. Gerson was heavily sedated. There are numerous occasions on the chart that he received large doses of Demerol and Phenergan. That's wrong. The plaintiff may have been restrained. No reason for him to use his hands. You know what occurred during the chart and later testimony. That's incorrect. As a matter of fact, when Mr. Brenner was questioning Dr. Horowitz, he even went on to say that the plaintiff received Librium, Vistari, and Seconal. Here's a person who tells you he spent many hours reviewing the chart. I think he said he's charging $500 for this opinion that the plaintiff was on Librium, Vistaril, and Seconal. Only on cross-examination did we find out Mr. Gerson never got those medications at all. To jump ahead, you'll remember when the nurse was on the stand, I pointed her right to that section of the order sheet in which the order was written by either Katz or Landau, and maybe the other two people, but it wasn't given. And here is Dr. Horowitz telling you that the patient received Librium, Seconal, and Vistari, and it's absolutely untrue. Dr. Horowitz is apparently taking the position, therefore, as I said, that Mr. Gerson had the complaints, but for one reason or another, the nurses did not write it down, or he had the complaints, and because he was in such a medicated state, he did not appreciate the complaints, and therefore, he did not make them to the nurses, and that is why the nurse did not write them down.
Too fast.
Okay.
Too fast.
No, first of all. Another testimony?